call that for hearing, please. Green and Monk. Can we have appearances, please?
May it please the Court, Your Honour, here for the appellant with my learner junior, Materne-Smith. I'll be speaking for 18 minutes, as will my learner junior, and we reserve 4 minutes for rebuttal at the end.
Yes, thank you very much.
May it please the Court.
May it please the Court, Your Honours, Skinner, appearing as senior counsel for the respondent, appearing with my learner junior, Cass, and is assisted by our instructing solicitor, Dunbabin. I will be speaking for 19 minutes, my learner junior will be speaking for 19 minutes, and we wish to reserve 2 minutes for Sarah rebuttal.
Thank you, Ms. Skinner.
May it please the Court.
Council should proceed on the assumption that we've read your written submissions, which we received overnight. Very helpful and detailed. You will, of course, need to highlight and develop the points you want to draw particular attention to. We're told we have a timekeeper who will keep you to those promises about 18 minutes, but we won't be too strict about the time limits because essentially we want to give you all a chance to develop the arguments orally to us. Yes, Mr. Beer.
May it please the Court, Your Honours, this case involves a set of self-drafted settlement terms which were commercially acceptable to the parties.
Just let me ask you about that. Do we know that they were drafted by the individuals?
Your Honours, the appellant takes that position from the trial judgment.
Thank you. I didn't trouble you further. It's interesting, given the rather formal language used, that lay people would have been capable of drafting something in this form, that was all.
Understandably, Your Honour, is the appellant's position that while at times there was quite formal language, at other times there was pertinent inconsistencies used as to that language, appearing at the beginning of the putative deed and at the end, and those inconsistencies will be expanded upon. Your Honours, are the parties legally bound before the lawyers prepare that formal agreement? That is the question I will be addressing. The appellant's submission is no, the parties are not bound. My learner junior will then make submissions on whether certain provisions of the settlement are unenforceable penalties. In turning Your Honour's attention to my first submission, which is that the agreement was not legally binding. Now, Your Honours, you have a copy of the deed in front of you. I'm assuming at page 6 of the appeal book, the appellant submits at point 1 of our written submissions that the document prepared by the parties was a concluded bargain because it was subject to clause 3 and therefore falls under the third category from Masters and Cameron, 1954, volume 91 of the Commonwealth Law Reports, at page 353. May I have leave to dispense with full citations?
Yes, thank you, certainly.
Thank you.
We have had a quick look at Masters and Cameron. In my case, to refresh my memory, because it's a while since I've looked at it, but yes, you can take it that we understand generally the 3 categories defined in that decision.
Your Honour, clause 3 states that the agreement is subject to the preparation of a legal agreement acceptable to the lawyers, the parties on both sides, on the following terms and conditions. Now, Your Honour, it was held by the court in Masters and Cameron at page 363 that words such as subject to contract create a prima facie right that what has been a prima facie overriding condition, apologies, Your Honour, that what has been agreed upon must be regarded as the intended basis for a future contract and not as constituting a binding contract.
Yes, I noticed that when I looked at it again this morning, the phrase subject to the preparation of a formal contract was said to have the natural meaning for which you contend. That is to say, this isn't binding unless and until.
Yes, Your Honour, and the position in Masters and Cameron and the facts of those cases contained a clause of great similarity to the present case, and in that case, subject to the above terms and conditions, was deemed insufficient to suggest that the parties did not, suggest that the parties intended a further future contract that was to be legally binding. It is the appellant's submission that the similarity between the words of Masters and Cameron in the present case is relevant. Now, Your Honours, it's not the appellant's position that simply because the words used in Masters and Cameron in the memorandum of transfer and the words used in this fugitive deed are similar means that the court is bound to say that it falls under the third category. But it is the appellant's position that the similarity is so close that it provides suggestion for the court that this indeed falls under the third category, as it did in Masters and Cameron.
The words are very similar, but aren't we, or should not we be looking at all of the circumstances of the case, which are not similar to Masters and Cameron at all?
It is, Your Honours, the appellant's position notes that the respondent suggests at 1.3 of their memorandum a similar position in that this case, the Masters and Cameron case, concerned real property. The present case obviously does not. The appellant's response to that is that while obviously this is not proprietary in nature, the ratio for the case in Masters and Cameron did not turn on the further terms being proprietary in nature, but rather turned on the express words being subject to the preparation of a more formal legal agreement. And is the appellant's submission that is relevant in the court regarding this is the third category.
But can I just follow up His Honour's question? We never look at a clause in isolation from the rest of an agreement, do we? And doesn't Masters and Cameron really just provide indicators of the direction wording might point you, but really leaving open the kind of broader inquiry His Honour was referring to?
And that the appellant will accept that that is the required position. By no means will suggest that the words must be considered entirely in isolation. We know that not to be the case from a traditional approach of the court, but the appellant also submits in response to that that the express words of the document are the most relevant for the court to consider, and the express words of the document should not be overruled by the surrounding circumstances.
So you say that the express words are so similar that similarity simply shouldn't be ignored. And if they were dissimilar, we'd be hearing all about it from the respondent.
It is, Your Honours, not the appellant's position that because the words are the same, the court must regard it as a third
I understand
category.
that, but we shouldn't ignore it all the same.
That is the appellant's position we currently adopt, that it should not be ignored. And
so just to pick up on the point, what's said against you is that the document is headed deed of settlement, and deed is a technical word typically used to signify agreement without the need for consideration, isn't it?
it is, Your Honours,
What do we make of that?
The appellant's position, and this is discussed in our written submissions at 0.3.3, so if Your Honours would turn somewhat to that position.
Yes.
It is the appellant's position that while a deed traditionally carries significant weight and is of great significance, these parties were laypersons who came together to draft a document, and Your Honours, referring back to the initial question as to the description of the deed, of the description of the document as a deed, it is the appellant's position that given these parties were laypersons, that simply they did not understand the significance of what they were doing, and the appellant supports that position with the inconsistencies I referred to previously, such as at the conclusion of the document it states executed as an agreement as opposed to executed as a deed. Furthermore, in clause 3, it states on a legal agreement acceptable to the parties of both sides, which the appellant submits suggests that the present agreement was not the legal agreement, and the more further, the later agreement was to be the legally binding agreement in that case.
Can I ask you this then? What do we make of the phrase at the end of the document to which you just referred, executed as an agreement? That's the very last line before they sign it. Wouldn't that suggest to the reader that each of them is saying, I am signing this as an agreement, not as a statement of intention to be bound at some time in the future. Why would they use those words?
It is the appellant's position that clause 3, in that they are not to be bound until the solicitors have considered the document more formally and provided substantive changes, is the relevant intention of the parties in using that phrase. Otherwise, clause 3 simply would not have been included. So while the parties executed it as an agreement, it was subject to the more formal agreement, which was impending from the solicitors. Your Honour, on that point of 1.3 of our written submissions, it is the appellant's position that acceptable to lawyers in clause 3 shows that the future agreement might contain whatever else the solicitors consider appropriate. It's the position taken by the courting masters as to that phrase. And it is the appellant's position that objectively the parties anticipated further changes of substance.
Well, alternatively, you would say they would recognise that they weren't lawyers and that they wouldn't want to bind themselves until the lawyers had had a look at it.
We would humbly adopt that position as well, Your Honour. However, we note that there are outstanding relevant principles that were not agreed to by the parties, and it's the appellant's submissions that this adds to the submission that they were not intended to be legally bound. Your Honours, there was no agreement as to the interest rate in the substantive terms of the deed. That was to be agreed at a time later. The appellant submits that that is a substantive, outstanding principle that has not yet been agreed. We know
the phrase executed as an agreement is qualified pretty much out of existence by clause 3. That's the effect of what you said, isn't it?
that is our submission.
Okay.
Yes. We note that in regards to the interest payment, that while there may be a suggestion that could reasonably be implied by the court, and we note that our learned friend suggests the use of the standard interest rate from the Supreme Court Act. We note that $130,000 appears in the recitals of the deed.
What's the current interest rate in the Supreme Court?
Can I assist the court in that?
I think it's reasonable, whatever it is.
We would humbly adopt that. We also note that 12% appears in the original statement of claim at the beginning of the appeal book. Your Honours, we therefore have a situation where we have a suggestion to use the Supreme Court Act. We have a further suggestion of $130,000 from the recitals, and we have a further suggestion of 12% presented in the statement of claim. These inconsistencies would suggest to us that the interest rate cannot simply be implied by the court. It is not so obvious that it goes without saying.
It's also a question of costs. Your point is, if the parties were intending to be bound by this agreement, then you would have expected them to finalise matters between them, including what the interest rate was and what the cost was, or at least how it would be determined.
Yes, Your Honours, and the fact the inclusion of the phrase to suggest further agreement, the appellant submits, shows that the parties at that stage, it was not clear that they had agreed on these points.
An agreement to agree is not a contract.
Yes, Your Honours, and the position is that the agreement was insufficient at this stage. While they had taken steps to settle proceedings, they had not done enough at that stage to reach an agreement.
Will you be dealing with the extrinsic evidence point?
Yes.
Well, we might come on to that. We'll make sure you've got time. Just before we do, two other aspects of the deed, which one I mentioned before. The first page of it, as it appears in our materials, has the look of great formality about it, and recitals introduced with the word whereas, again, would tend to suggest to me as a reader that this was intended to be formal and operative. Otherwise, why would you go through all the fancy language? And finally, why would you say at the bottom of that page, have thereby and hereby executed these presents by which they agree to settle. So it's really just the same question again. Aren't there quite strong indications going the other way, suggesting that this wasn't just jotting down the heads of agreement, this was a document which we're adopting formally?
As Your Honour, the appellant acknowledges that that is curious. The decision by the parties in that instance to follow formalities in some instances is a curious one. However, as I mentioned previously, and the appellant submits that the point has been put at its highest that the parties were laypersons and did not follow such formalities in all instances. In fact, were quite inconsistent. And it's the appellant's position that locating possible formalities that could be followed in a deed would be possible by laypersons, but that the use of the phrase legal agreement in clause 3 suggests that they did not intend the present one to be.
So that's the crunch clause, and although we have to look elsewhere, that remains the, as it were, the paramount indicator of intention.
That's correct.
Good, we understand that. Do you want to move now to your extrinsic evidence arguments?
Thank you, Your Honours. The appellant's, the second issue that the appellant has with the findings of Judge Bear was the admission of extrinsic evidence in determining the intention to contract. Your Honour, is not the appellant's position that the use of surrounding circumstances and extrinsic evidence can never be used to suggest an intention to contract. That was not what the High Court told us in Allen and Carbine. However, what has been made plain is that, and this was the principle from Chief Justice Gleeson in ABC and Commonwealth Games Limited, that where it was found that in instances where the parties have signed a single document which contains such expression as subject to contract, the question as to whether a concluded bargain was found will, and I quote, ordinarily turn upon the construction of the single document referred to, and that questions may arise as to the admissibility of the extrinsic evidence. It is therefore, Your Honour, the appellant's position.
The Chief Justice in ABC in 14 Commonwealth Games also said, did he not, that subsequent communications between the parties and actions between the parties can be used for the purpose of determining whether the language in the agreement expresses the intention to enter or not enter contractual relations. I thought His Honour the Chief Justice in ABC and 14 Commonwealth Games was saying you could have regard in this case to the fact that they subsequently acted on the agreement by having the proceedings dismissed.
It is the appellant's position that these surrounding circumstances are relevant. However, they are less relevant in instances where the parties have signed a single document, and that the objective intention of the parties should be gleaned primarily from that single document. And it is the appellant's position that such, that the clause and clause 3 again, as I mentioned, was sufficiently certain in that case so as to not overrule the surrounding circumstances. Now, Your Honours,
so just to be clear, you accept that, conscious of the time, but we want to finish this point with you. You accept that His Honour was acting correctly in having regard to the conduct after the signing of this document, but your submission is that whatever inference would be drawn from that conduct couldn't outweigh the clear intention of clause 3.
That is the appellant's position, and that stands in somewhat contrast to the traditional parole evidence rule, in that this is determining an objective intention to contract. I note that my learned friends provide the case of Sion in New South Wales to support the subsequent conduct position. The Sion case was an oral agreement made between parties. It is therefore distinguishable on the appellant's position.
Yes, thank you.
In this case, I should continue with responding to Your Honour's question, however, in saying that it is the appellant's position that, irrespective of whether the court has regard or sufficient regard to that extrinsic evidence that occurred subsequent, such as the dismissal of the proceedings, it is the appellant's position that that does not indicate, regardless, that does not indicate an intention to be immediately bound.
Why is that?
The dismissal of the proceedings reflects a unilateral intention of the respondent, who was the plaintiff, and that the respondent, in dismissing the proceedings, expressly added a right of reinstatement to those proceedings, suggesting that he was aware that a further agreement may not be executed, and therefore wanted to provide that additional barrier, I suppose.
Yes, thank you. With respect, that seems to me to be a point well taken, because it's familiar to us that where proceedings are settled, the right of reinstatement is reserved. I think it's inherent in any event, but you point out that that shows that this wasn't, as it were, viewed as the end or irreversible.
Furthermore, the appellant's decision to consent to that order was a natural one, given that, obviously, given a choice between continuing litigation or having that litigation ceased is an obvious position the appellant would take.
Thank you very much. Now, were there other submissions you wanted to make? Otherwise, I think your time has expired.
No, those are my
Thank
submissions.
you for your assistance. Just give us a moment, please. Just need to do our score sheets. Yes, thank you, Mr. Materne-Smith.
May it please the Court. Your Honours, the appellant's third and final submission is that if the deed is binding, then Clause 2 is nonetheless an unenforceable penalty. It contravenes the rule against penalties because what we really have here is a settlement for $100,000 without admission of any liability. But if the appellant doesn't pay by the stipulated deadline, then the deed would have the effect of multiplying the debt by 6.5 times.
As opposed to reinstating it to its original state.
That would be our, so we would only adopt that, Your Honour. So the effect of that, Your Honours, is, on our case, a clear penalty. In cases like this, we submit that a two-step test applies. The first question will be to ask whether a pre-existing or acknowledged debt exists. And if not, then the second question will be whether the amount in Clause 2 can be characterised as penal. In turning to that first step, Your Honours, we submit that Clause 2 of this deed reflects no acknowledged or pre-existing debt. We would use the usual approach to contractual construction for this, and state that a reasonable person would not understand the terms of this deed to represent such an acknowledgement in circumstances where, and this is the key point, Your Honours, Clause 1 uses the words, without admission of any liability. That operative clause, on our case, is inconsistent with the finding that there was any pre-existing or acknowledged debt.
What about the recital? The recital makes it plain, doesn't it, that your client acknowledges indebtedness of $650,000.
Your Honour, this is another curious point in this self-drafted agreement. Your Honours, the recitals would, on our case, represent an acknowledgement of a claim of $650,000 as distinct from an acknowledgement of a pre-existing or accrued liability. And that, although perhaps difficult to reconcile with my learned friend's interpretation of those words, would flow from a recognition that the amount here was in dispute, and the recitals also say that the parties wished to avoid the expense of further litigation. So in our submission, the parties recognised that the amount remained in dispute, which is why we have this putative deed before us.
Can we just take that a bit further? Because, like as I know, I'm struck by the clarity of the language in the recital. Let's just read it. Susan Greedy hereby expressly acknowledges the said indebtedness to John Money, and that's a reference, if we're saying back to the word indebtedness in the preceding recital, which is a reference to the proceedings brought for her indebtedness in the sum of $650,000. Now, it's not clear to me at the moment what explanation there is for the second recital, the acknowledgement, unless your client meant what she said.
Your Honour, the language certainly poses some difficulties.
Yes.
If Your Honours were not to accept our submission that this language refers more to an acknowledgement that a claim had been made, then we would nonetheless submit that the recitals could not displace the operative term that the payment was to be without admission of any liability. That's at clause 1 of the deed, Your Honours. And in support of that proposition...
And you would say, again, substantive clause must, when it's as clear as clause 1 is, override anything said in recitals.
Certainly, Your Honour. As was stated at paragraph 380 of Franklin's and Metcalfe's trading, the recitals cannot cut down the operative words. So certainly, Your Honours, the language here poses a difficulty for the court to contend with, and it is one of the several inconsistencies in this deed. But, Your Honours, we've proposed two possible resolutions to that. Either the reading that it refers to an acknowledgement of the claim, or alternatively, a reading down of the recitals subject to the operative terms.
And to be clear, you say without admission of liability means that there's a reference back to the proceeding identified in the recital where the debt is claimed, and your client's saying, I'm not admitting that I'm liable for that debt.
Yes, Your Honour.
Although a little later in clause 1, it uses the phrase, acknowledge the indebtedness to John Money. It's not easy, is it?
Your Honour, if the parties had the opportunity to have their lawyers draft the formal legally binding agreement, we can only hope that some of these difficulties would have been resolved.
Not necessarily, but is a possible explanation that if one looks at the defence, and are we entitled to look at your client's defence where she admits that $650,000 was advanced, the issue seems to be raised about whether it was part of it. So one possible explanation might be, she acknowledges that there's a sum of $650,000 that was advanced, but it's simply her contention is that it's not yet repayable under the terms of that original agreement.
Yes, Your Honour, I would think that is a fair reading of the defence. Certainly, there was an admission of the advance in terms of the pure transfer of funds, and this is a point on which His Honour Judge Bear, with respect, heard, His Honour considered it seems that the admissions were broader than that. But on our submission, the admissions were not any broader than that. And certainly there was never an admission that the liability had accrued or had become a pre-existing debt payable on demand.
Indeed, the denial of paragraph 1 in the statement of claim is a clear indication of what you've just put to us, that it's alleged that this was a loan, and your client says, no, it wasn't. Admits again that monies were advanced, but no admission that there was a loan.
We would normally adopt that, Your Honour.
I'm not sure, though, how much help that gets you when looking at the agreement. And what's said in a formal court document is one thing. When it's the document signed by your client, it's more obviously when she signs it an expression of her own position, isn't it?
Certainly, Your Honour, the very words before the court in the deed will be the touchstone of this analysis. And Your Honours have already adverted to some of the difficulties in using those words. However, Your Honours, we would further add that in circumstances where the parties have drafted the settlement terms themselves, the court can consider that the document wasn't the product of professional drafting and place perhaps more weight on the substance of the transaction. That was the approach taken by the majority in the case of Tulaco and Tulaco, which also involved a self-drafted settlement deed. And on our submission, the substance of this transaction can be stated in roughly the following terms. There was an advance of $650,000. The terms of the advance, which were oral, are fiercely disputed. Whether any amount had become due and payable was fiercely disputed. And the parties came to a commercial decision that $100,000 only would be the settlement sum.
What do you say about the proposition put against you by the respondent that it should be characterised as an alternative? You can pay the $100,000 within the period stipulated, or otherwise you could pay $650,000 after that date. What do you say to that argument?
Your Honours, we don't accept that argument, and there are two reasons for that. The first is that the second alternative is illusory because there is no deadline or time extension provided by Clause 2 of the deed. It seems then that Clause 2 just provides for an immediately payable sum of $650,000 once 30 March passes and payment hasn't been made. So in that sense, there is no extension of time. But further, Your Honours, all penalty cases could be described in a way as an alternative stipulation provision. Certainly, in the case of Pachoco, the most recent High Court authority on this point, which considered banking fees, one could suggest that the imposition of the banking penalty fees were the alternative to paying on time. Nonetheless, the court was not persuaded by that logic. So in our submission, it isn't an alternative stipulation, and this is reinforced even further by the fact that for a minute's delay in payment, the uplift could be $550,000. Now, if the language had provided for a period of that extension of time, then this might be a different case. But regrettably for the respondent's submission, there is no such language.
If we find against you that on a proper construction there was an acknowledgement of indebtedness of $650,000, do you lose on this point?
Your Honours, we would lose on that point.
I respect it's a proper concession. It signifies, doesn't it, that the construction against you has the consequence that it's not a penalty because it's referable to an acknowledged prior debt. Is that the basis of your concession?
That is the basis of the
So there's
concession.
no second step which says, well, even if it's an acknowledged debt, it's still a penalty.
Yes, Your Honours, that is our position. And as Your Honour adverted to, it's a relatively narrow concession contingent upon the first step of our argument phase.
If I remember Teleco correctly, that was a case where there was a relatively small sum payable in settlement. In default, the provision was for a very substantial sum, but the Court of Appeal held not a penalty. Am I right about that?
Yes, Your Honour.
So that the disproportion between, which was much greater there than it is here, between the settlement sum payable and the default sum is again not conclusive of the penalty question if the debt of the larger amount has been acknowledged.
Yes, Your Honour. But by contrast, the amount of disproportion need not always be significant. The question on our case, which brings us to the second step of the inquiry, is whether the amount is out of all proportion to the interests of the party which the provision is designed to protect. And so, for example, even a relatively small difference in amount, for example, $18,000 in Zenith Engineering and Queensland Crane and Machinery, could nonetheless result in the secondary payment being characterised as a penalty.
Yes.
So it will turn certainly, Your Honours, on the underlying rights or the implicit acknowledgement. In Teleco, it wasn't penal, but in Zenith Engineering, which we consider this case is most analogous to, even a small amount could be out of proportion to the interests of the party seeking to enforce the debt.
Can you tell us, was that a case in which there wasn't an acknowledgement of an obligation or an indebtedness with respect to the 18,000?
Yes, Your Honour. In that case, there was an acknowledgement of the claim that had been made.
Not of an amount. So you did go to the next step. Let's look at whether the default amount is commensurate with the interest being asserted.
Quite so, Your Honour. And Your Honours will recall that I advanced at the beginning of my submissions a reading of the recitals that the words acknowledgement in those recitals were an acknowledgement that the claim had been made, not an acknowledgement that the debt had now fallen due.
So does it follow that if there were a disproportion, it is in the smaller amount rather than the default amount?
The disproportion that's relevant on our submission, Your Honour, would be the disproportion between Clause 2 and the right, the underlying right of the respondent. On our submission, the respondent has no underlying right to seek payment of the $650,000.
I understand you say that. On the respondent's case, I suppose they would say, well, look, the 100,000 is disproportionately low rather than 650 being disproportionately high. It's the other side of the coin that you're arguing.
And that alternative, Your Honour, poses an additional question.
Does, doesn't it? Yeah.
The question in my mind, Your Honour, would be if, as the respondents contend, the $100,000 is a mere indulgence for prompt payment, then why would the indulgence be in the amount of 85% of the total debt? The respondent could easily have proceeded to judgment and recovered the whole amount.
Isn't the answer to that, sometimes people resolve on that basis in the hope that the insolvency of the defendant doesn't stop them from getting all of it. So $100,000 being paid in cash is better than $650,000 proof in a bankruptcy.
Your Honours, as a general principle, certainly. Unfortunately, the facts don't provide any basis for determining the solvency or otherwise of the business.
When you go to the bar, you'll understand these commercial matters.
Mr. Materne-Smith, your time hasn't quite run out, but we fully understand the submissions you've made. Unless there's anything you want to add, we're happy for you to conclude your submissions.
In my final part of time, Your Honours, I'll make just one reference, further reference to my learned friend's submissions. I'm looking at 1.2.1 of my learned friend's submissions, and I think that might be the third lot of 1.2 in there. They appear to concede there, Your Honours, that the amount is incommensurate to the interest protected by the primary obligation. I have to profess I read that with some disbelief, and I'd be very interested to hear the submission on whether or not that was intended to be the concession it appears to be.
I'm sorry, I'm
8.2.1 is on the...
It's closest to footnote 19 in the main text, Your Honours, of my learned friend's memorandum.
yes, thank you.
So that's probably consistent, isn't it? Or is it consistent with your approach that the success or failure of this point is depending upon the interpretation of whether there was an acknowledgement of a debt of $650,000?
Yes, Your Honour. I know that I am out of time, but in response, the answer is yes.
Thank you. No, I had noted that 1.2.1 and we'll take it up with counsel for the respondent. Thank you for your assistance.
Thank you.
We're going to adjourn briefly to put it down our score sheets, give the parties time to draw breath. We'll resume in about 10 minutes. Yes, Ms. Skinner.
May it please the Court. Your Honours, this morning I'll be responding to points 1 to 3 of the notice of the appeal, submitting that the deed of settlement dated the 30th of September 2018 is a legally binding and enforceable contract by reference to the true meaning and effect of its terms. Following this, my learned junior will present on our second submission, responding to points 4 to 6 of the notice of appeal and submitting that the doctrine of relief against penalties is not available to the appellant, and as the $650,000 payment is not capable of being characterised as a penalty. Now, Your Honours, to briefly outline the structure of my submissions, I'll begin by going through some contractual principles that we see as relevant in the present case. I'll then respond to my learned friend's analysis of the Masters and Cameron categorisation. Finally, I will move to the inquiry as to whether the parties intended to be bound, submitting that subsequent conduct was admissible as extrinsic evidence. However, in the case that it is not, a construction of the terms of the deed similarly lead to the inference that the parties did indeed intend to be bound.
Thank you.
Now, Your Honours, a contract is a legally binding agreement that is created where parties have reached final agreement over the terms of their bargain. In the present case, the parties had indeed reached finality in their negotiations and had therefore proceeded to give form to their common intention to settle the dispute by creating a signed written agreement. Thus, we submit that the learned trial judge was indeed correct in his determination that the deed of settlement was a binding contract. Supporting the decision of the learned trial judge, we note the long-standing position that courts are reticent to strike down contractual bargains and will strive to uphold them wherever possible. Indeed, in the 2013 judgment in this court of City Rose Trading and Booth, Justice Emerson stated that language, when constructing a contract, language used will be interpreted broadly and fairly and not narrowly or pedantically. An agreement will be enforced
That's
if
a
it is not...
construction point, though, isn't it, Skinner? Isn't this a different question? This is a question of whether a contract exists at all.
Yes.
Certainly, once a contract exists, the court will go to some lengths to give a commercial meaning to the terms rather than strike it down, for example, for uncertainty. But whether or not the parties intended, whether or not there's a contract will be determined by whether the court determines objectively the parties demonstrate an intention to be legally bound, won't it?
Yes, Your Honour. So we understand that the inquiry relevant, whether or not the parties intended to be bound, is based upon a construction of the terms, and therefore the principles relevant to constructing a contract are relevant here. We'd simply submit the court's position and indeed the doctrine of freedom to contract are relevant here in that where these parties have freely and willingly entered into this agreement, a court should be reticent to strike it down. We're simply submitting that there should be a foundational principle in consideration of this contract.
So in construing the terms of a contract, a written contract, the court won't have regard to subsequent conduct between the parties, will it?
Your Honour, we submit that there are instances in which subsequent conduct can be relevant, and we also further note the exception to, as Your Honour has outlined, the parole evidence rule. There is an exception in the case of ambiguity of the terms, and in my later submissions I will be noting that there is indeed ambiguity in the present contract. So, Your Honours, we note here that in the present case we do have two parties who have freely and willingly entered into an agreement with the purpose of resolving a dispute that is owed by the appellant. And throughout the proceedings, the appellant has acknowledged that the respondent provided to her a sum of $650,000, and she is now seeking to avoid any obligation to pay this debt by undermining the agreement that she herself has entered into. Turning now to the construction of the deed, Your Honours, we accept 2 points made by our learned friends. Firstly, that the relevant inquiry is whether or not the parties intended to be bound by the agreement. And secondly, we accept that a Masters and Cameron analysis is appropriate in the present case. However, we contend that the conclusion reached by counsel for the appellant in respect of these inquiries are incorrect. Counsel for the appellant has sought to persuade you that the deed of settlement may be correctly categorised as a Type 3 Masters and Cameron agreement. However, Your Honours, we submit that in line with the finding of the learned trial judge, the deed is much more accurately categorised as a Type 1 agreement, in which the parties have reached finality in arranging all the terms of their bargain and intend to be immediately bound. We submit that the subject to clause merely reflected the parties' intention that their lawyers would put form to their agreement and not that there would be any change in substance. We note that agreement of such a nature was recognised in the British case of Roster and Miller, and at page 1151 of this judgment, Lord Blackburn stated that as soon as the fact is established of the mutual final assent of the parties, so that those who draw up the formal contract have not the power to vary the terms already settled, I think the contract is completed. And noting that this is a British authority, we also note that this position has been accepted in Australia through consideration of Roster and Miller in Masters and Cameron. Your Honours, we also note here that recent case law has accepted these principles outlined by Lord Blackburn and has erred towards finding concluded agreements as soon as it can be established that the terms of the agreement are settled. While there is presently no authority for this in this court, we note that in 2015, the Western Australian Supreme Court found in Vantage Systems and Parole that parties were bound to an agreement that had not yet been drawn up. Now, in that case, we had exchanges of emails and letters between two parties regarding a lease agreement, and there was an understanding that following the agreement of the terms, a formal lease agreement would be drawn up by the solicitors. However, even without this formal agreement, the Western Australian Supreme Court held that because the parties had reached finality in the determination of the terms, they ought to still be bound by it. So there is a clear distinction here that the case law has made out in Masters and Cameron and similar cases, that there is a significant distinction between when the parties are in negotiation and once they have reached finality. And as soon as they have reached that point of finality, we submit that the agreement is binding and therefore that both parties are bound by their obligations.
Is there anything in this agreement which shows finality?
We submit that the fact that it states at the end executed as an agreement is one indicator that finality has been reached, and some further indicators will be outlined in my later submissions, Your Honour.
I was wondering about the language of clause 3.
Yes, Your Honour.
Is that something you'll be coming to?
It is indeed,
Thank
Your
you.
Honour. In the alternative, we also submit that possibly a categorisation under Type 2 of Masters of Camera would be appropriate. However, in the interest of time, we'll rely on our written submissions here, noting that the practical effect of a Type 1 determination or a Type 2 will be indeed the same.
Just on that, as I mentioned earlier, I did have a look at Masters and Cameron earlier today, and I wasn't quite clear what the second category involved. Wasn't the effect of it, let me start again, it's not the same as category 1, is it? Isn't it to say there is an agreement to take action, to have a formal agreement drawn up?
Yes, Your Honour. So in the case that it would be a Type 2 agreement, the parties would be bound at minimum to the obligation to draw up a formal agreement, which we would submit then would have the exact same consequence in that the appellant would be bound to draw up this formal agreement on the above terms and conditions as stated, and then therefore the practical effect of this would be that the appellant would still be liable to pay this money to
Well, just let me ask you, that's why I raised the question. I'm not sure with respect that's right. All you can enforce on that analysis of the second category is a promise to bring about another agreement.
Yes, Your Honour.
So if that's a category 2 agreement, there's no promise binding on the appellant to pay any money, is there? All there is an obligation to ensure that the lawyers create an agreement under which there will be a promise to pay.
Yes, Your Honour, we accept that, and we note that therefore we would be submitting that the appellant is in breach of her obligations to execute this formal agreement, and that once this formal agreement is executed, the same obligations would apply. So perhaps the obligation to pay money has not yet arisen, but it would be a necessary consequence of the obligation to put this formal agreement into execution. And we note that on the facts we have no evidence as to why this formal agreement has not been concluded, and so we do not wish to make assumptions about why that's the case.
If it's just an agreement to make a formal agreement, you can't recover the debt, can you? Because you have no enforceable promise to pay.
We would submit that if the court does indeed find this Type 2, then we would seek an order that the appellant must enter into a formal agreement on these terms, and that a necessary consequence of this would be that a formal agreement would be drawn up, and then the appellant would become liable to pay this sum.
Yes, thank you.
Thank you, Your Honour. We also note, as previously raised, my learned friend's submissions, that we only seek to rely upon Masters and Cameron for the general principles of law outlined within the judgment. We do not, we submit that we should exercise caution in analogising with the facts of that case because of the differences. Now, Your Honours, turning to the inquiry related to the intention of the parties, we note that to ascertain whether the deed is a binding contract, the court must determine whether the parties intended to create legal relations, and that this inquiry involves an objective assessment of the subject matter of the agreement, the relationship between the parties, and the surrounding circumstances. And Your Honour, this inquiry comes from the High Court case of Homogeneous and Greek Orthodox Community of South Australia. The learned trial judge, we submit, did not err in having regard to the subsequent conduct as is suggested in ground 2 of the appeal. In assessing parties' intention to be bound, it is established that consideration may be had to the parties' conduct and communications after the contract is severed.
What's your best authority for that proposition?
We have two authorities here, Your Honour. Firstly, a Scion and New South Wales trustee, and secondly, the Victorian Supreme Court case of City Rose Trading, in which it was found that the likelihood that parties intended an agreement to be binding is strengthened where they have acted upon the agreement.
What about the appellant's point that Scion was about an oral agreement?
Once again, Your Honour, we seek only to rely on Scion for the principles of law, and we are in no way seeking to analogize with the facts of the case. Indeed, we note that in relation to these points, whether or not extrinsic evidence is being, it can be considered in the case of Scion, the court found that it's not possible to prescribe the circumstances that the court may take into account to determine parties' objective intentions, and at times an assessment may require the consideration of extrinsic evidence. Each of the cases has stated points to the effect that what evidence is relevant and is admissible will turn on the facts and the circumstances of the case at hand. We know that the parole evidence rule exists to ensure that extrinsic evidence is not used to contradict or alter the terms of a contract or a bargain.
But you rely, don't you, on the fact that, in particular, on the fact that the proceeding was dismissed?
Yes, we do, Your Honour.
And that's what the learned trial judge relied upon. But isn't that equivocal? Because plainly the parties thought either had entered into a legally binding contract or thought they would. In either event, it's explicable, isn't it, and consistent with the fact that they would seek to dismiss the proceeding with a right of reinstatement in the expectation that ultimately they would enter into a binding agreement.
Yes,
Doesn't
Your Honour.
it cut both ways?
Perhaps it is better to characterise our submission that rather than the subsequent conduct of the parties, it's the lack of subsequent conduct. Perhaps, hypothetically, in the case that the parties had sought to dismiss the proceedings and had then followed it up with further negotiations, this would have indicated that there was no intention to be bound. However, we note that on the evidence and the facts presented before the court today, nothing occurred in the 8 months between the settlement, the deed of settlement and the reinstatement. Your Honours, if they had not intended to be bound, why did they not execute a further formal agreement? And why did they not continue to negotiate these terms? We submit that the respondent did indeed intend to be bound and felt that they were both bound, and that this intention can be objectively ascertained on the terms of the agreement.
Just going back to the Scion point,
Yes,
would you accept that the weight to be given to subsequent conduct is likely to be greater where there is no written agreement?
Yes, Your Honour.
So, to that extent, you accept that your position is more difficult because you do have a written agreement in relation to which you seek to rely on subsequent conduct.
Yes, Your Honour. As Your Honours have raised, as I noted earlier, if Your Honours are not satisfied with the authorities we have provided in relation to subsequent conduct, we know that there is an established exception to the parole evidence rule where a term is ambiguous. We submit that there is inherent ambiguity in the subject to clause. The mere fact that Masters and Cameron outlined 3 possible categories that may arise from this indicates the inherent ambiguity, and therefore we submit it is indeed instructive for this court to look to extrinsic evidence to construct this contract. As per my submissions above, we submit that the trial judge was correct in his consideration of extrinsic evidence. However, Your Honours, even if regard was not permitted to be had, a construction of the terms of the deed of settlement similarly indicates that the parties did indeed intend to be bound. Firstly, the document is entitled Deed of Settlement and concludes with the words executed as an agreement. Now, our learned friends have attempted to point towards this inconsistency as evidence that the 2 parties did not understand the consequences of an agreement. This does not, however, suggest that the parties did not understand the impact of the deed, but rather that they are unfamiliar with the legal convention, which we submit is known only to those with legal training, that a deed is usually concluded with that statement. And indeed, it is our submission that the phrase executed as an agreement simply supports our contention that the parties were no longer in this phase of negotiation and had reached finality. Further to this, Your Honours, we note that our learned friends have placed great emphasis on the fact that it was lay people that entered into this contract. However, Your Honours, we're dealing with a situation in which 2 parties, one of whom has begun her own financial business, one of whom has lent her $650,000 to enter into this business. It is unlikely that these are entirely unsophisticated parties. As business people, it is likely that they would have some understanding of the effect of commercial contracts and how to enter into these. Furthermore, Your Honours, we would submit that while they may not have understood the technical definition of deed, any layperson with any level of experience would understand the significance of signing a written document that includes obligations. People are required signatures all the time and understand that this indicates that they have read and agreed to.
But again, you need to confront, don't you, what's in clause 3?
Yes, Your Honours.
Because assuming a degree of sophistication, and I'm not sure how much assumption we can make in that regard, they've been careful to say is made subject to the preparation of a legal agreement, haven't they?
Yes, Your Honour. In line with our analysis of Masters and Cameron, we submit that this is indicative of the parties' intention, only that their lawyers would put into a different form, perhaps a more proper legalistic form. However, there would be no substantial change to the agreement, and the fact that they have reached agreement on the major points of their dispute, we submit that the intention was to immediately create legally binding obligations. We also note here that our learned friends have pointed to the lack of interest rate.
Before we come to that, because I want to stay with clause 3.
Yes.
Is there anything in the language of clause 3 which you say supports your contention that there is no scope for new terms and conditions to be agreed?
Yes, Your Honour. Here we point to the words on the terms and conditions as above. Thank you. Turning to the interest rates briefly, we submit that while the interest rates and costs are yet to be determined, these terms are not essential for the contract and are a secondary consideration. As indeed Your Honours have already pointed out, there is a provision for a standard default interest rate of debts owed at section 58 of the Supreme Court Act, and we submit that the presence of this suggests that the determination of interest is not an essential condition for a contract.
That doesn't report to be a reasonable rate, does it? That's a penalty rate.
Your Honour, I cannot assist the court in what this rate is. We simply note that there have been instances relating to the settlement of a loan where an interest rate is imposed by the court rather than agreed upon by the parties. And the fact that this was left to be determined is no indication that the parties did not intend to be bound. In summary, Your Honours, the deed of settlement dated 30th of September 2018 was a binding contract by reference to the true meaning and effect of its terms, and the learned trial judge was indeed correct in his categorisation of this deed. Following these submissions, we seek an order that the court uphold the decision of the county court in finding that the deed of settlement was binding, and we seek an order that the appellant be ordered to pay the respondent $650,000 plus interest and costs. May it please the court, those are my submissions.
Thank you for your
Just before you sit down,
Yes, Your Honour.
go to clause 3 again. Do I correctly understand your submission to be that clause 3 is to the effect that the role of the respective lawyers is confined to putting the agreements in clause 1 and 2 into a legally correct form and no more than that?
Yes, Your Honour. That is our submission.
Thank you.
Were you able to find any authority where the court has upheld as immediately binding an agreement which, as in Masters and Cameron, was expressed to be subject to execution of a formal contract?
Your Honour, once again I point to the Western Australian Supreme Court case Advantage Systems and Parole, and in that case the terms of the agreement were determined solely through correspondence between the parties, and while I cannot assist the court with the exact phrase that was used, there was an understanding between both parties there that the lawyers would still draw up a formal lease agreement. However, the court found that even prior to the drawing up of this formal agreement, the parties were bound by those obligations they had agreed upon, and we submit that that's analogous to the present case.
Thank you, Mr. Chairman.
And please the court.
May it please the Court, Your Honours, I will be addressing the Respondent's second submission, which relates to grounds 4 to 6 of the Notice of Appeal. Our submission is broadly that Clause 2 of the deed is not capable of being characterised as a penalty, and the doctrine of relief against penalties is therefore not available. Now, Your Honours, on this issue, our learned friend addressed this inquiry as one which involves two questions. Firstly, whether or not there was an acknowledgement of debt, and secondly, whether the clause was a penalty. Our submission is that these are not two discrete issues, but rather, where a pre-existing debt is acknowledged, this serves as an exception to the doctrine of the rule of penalties, as in accordance with the approach outlined by His Honour Chief Justice Gibbs in O'Day and all states.
Let me ask you about that. Is it really an exception, as you just expressed it, or isn't it an important indicator relied on to say, well, it's not a penalty at all?
Your Honour, our submission is that in subsequent interpretations of this doctrine adopted by the High Court in O'Day and all states, such as those heard in this court of Cameron and UBS in 2000 and Calcorp and 271 Collins in 2010, the courts have applied this test essentially as an exception, in that if it is demonstrated there is an implicit acknowledgement, what would otherwise constitute prima facie a penalty will not be considered a penalty.
And what would point you to it being a penalty in the first place, subject to this exception?
Your Honour, we submit that the law relating to penalties and this prima facie test that a clause must satisfy to constitute a penalty is outlined in Andrews and the High Court case of Andrews and ANZ Banking Group. And we submit, I will touch on that later in my submissions.
Good, will you come to it when it's convenient? Thank you.
I merely need to note here that our submission is that both the issues outlined by my learned friends fall under the same overarching inquiry of whether or not a clause is a penalty. And in accordance with the approach adopted by the High Court and the inferior courts, the inquiry is best understood as being comprised of two different stages. That is, it is first necessary to determine whether or not a clause is prima facie a penalty in accordance with the Andrews test, and it is then necessary to determine whether it falls into either of the exceptions that may be argued to apply to the present case. Your Honour, first I move to this issue of whether Clause 2 satisfies prima facie the threshold test outlined in Andrews and ANZ Banking Group. And in that case, the High Court found that a provision will prima facie be a penalty where it imposes an additional liability on a party in the event that a primary stipulation is breached, and where that secondary stipulation is intended to secure compliance with the primary stipulation. In the present case, Your Honours, we submit that the $650,000 payment was not intended to secure compliance with the first clause, but rather, as I will elaborate on later in my submissions, it was intended merely to recoup the full debt that was already owed by the appellant if she failed to pay that $100,000 fee. And it is therefore not in the nature of a security as is required by the High Court judgment in Andrews. We note further, Your Honours, that in Andrews and ANZ Banking Group, the High Court found that the doctrine of relief against penalties has its origins in equity, in the operation of the English Court of Chancery.
Yes.
Your Honours, these origins are significant in the present case, due to the long-standing equitable maxim that he or she who comes into equity must come with clean hands. And this is patently not true of the present case.
Is that an argument you've put in your written submissions?
Your Honour, we note that we have referred to the case of Andrews, which sets out the general principles.
I understand that, but there's a whole body of law on good conscience and clean hands. I just wasn't conscious that that was an argument you were advancing here.
Your Honour, our submission is that this is merely an overarching principle that must be kept in mind in the inquiry of whether or not there was a pre-existing
Well, I
debt.
follow that, but if you're about to make submissions to support the notion that the appellant doesn't have clean hands,
if it pleases Your Honours, I'm happy to move on from this submission. It's merely a maxim, a broad principle, rather than a specific point of law that we submit must be kept in mind throughout the
What
course
would
of
you
this
say
inquiry.
we should have regard with in support of your submission of unclean hands?
Your Honour, we submit that this is a case where the appellant seeks to evade a debt that she admits that she was loaned, and she seeks to invoke this equitable doctrine of relief against penalties in order to do so. And this is why, Your Honours, this is merely part of the submission that it was a pre-existing debt.
good, we understand that, thank you.
Thank you.
Just staying with Andrews. is your submission that within the language of Andrews, the clause 2 does not impose an additional liability?
Not exactly, Your Honour. In fact, as was noted by my learned friends, we have conceded in our submissions that clause 2 does impose an additional liability compared to that imposed in clause 1. And that is, on a plain meaning of the words, incommensurate to the clause 1. We would not seek to waste the court's time attempting to argue otherwise. Rather, where the present clause falls in satisfying that Andrews test is that it is not intended to secure compliance with the first clause, as it is rather simply a case where a debt has been indulged, and in the case that the appellant failed to pay the debt, clause 2 operates to recoup that full debt. And Your Honour, we note that it was essentially conceded by my learned friends that this issue does hinge on that issue of whether or not a debt was acknowledged.
And from your point of view, if in fact we form the view that there was no acknowledgement, it's able to be discerned from the agreement, that you must fail on this point.
Not precisely, Your Honour. We note that we have set out 2 alternative exceptions to this prima facie test. The other I will reach towards the end of my submissions, which is that it is merely an alternative stipulation or an option under the agreement. If either of these 2 are found to be the case, we submit that the clause 2 will not constitute a penalty.
So to come back to the additional liability language, the so-called exception is if that additional liability, in this case the extra 550,000, is referable to a acknowledged pre-existing debt, then it loses its prima facie character as a penalty. Is that
precisely, Your Honour? That is the effect of this exception, as has been discussed by this court in Cameron and UBS and cases such as CalCorp.
Yes, thank you.
Your Honours, I now move to that exact exception, this first exception to the doctrine of relief against penalties, which concerns indulgence of debt. It is well established that the doctrine of penalties will not void payment, a stipulated payment which represents a present debt at the time a contract is formed. For that authority, I rely on the judgment of His Honour Chief Justice Gibbs in O'Day and all states. Our submission is that the learned trial judge was correct in applying a long line of authorities, including those in this court, including Cameron and UBS, heard in 2000, CalCorp at 271 Collins, heard in 2010. And in these cases, this court found that where a deed of settlement indulges an acknowledged pre-existing debt, but requires the full amount to be paid in default of that indulgence, the stipulation will be a penalty if the deed can be read to acknowledge that the debt was owed.
What does the word indulge mean here? It's an unusual word to find in the jurisprudence. What does it mean to indulge a debt?
Your Honour, by the use of indulge, we merely mean that the respondent has provided the appellant a chance to pay a lower sum in satisfaction of that otherwise owing debt. That is, in our submission, the accepted meaning of an indulgence of that debt.
Thank you.
Your Honours, we note that throughout this inquiry, my learned friends sought to establish an analogy to the case of Zenith Engineering and Crane Machinery, which was a case heard by the Queensland Court of Appeal, to support their contention that the original amount owing was never established. We submit that Zenith Engineering concerns a set of facts entirely distinguishable from the present case. And in fact, Your Honour, Zenith was considered at length by this court in CalCorp, in which Justice Nettle found that, and I quote, "The decision in Zenith turned very much on the terms of the deed of settlement there in issue." Justice Nettle also found in CalCorp that Zenith was distinguishable from cases such as the present on the basis that the deed made no acknowledgement of indebtedness at all, and there was no admission at all on the prior pleadings that there was an obligation to pay something. Hence, we submit that the learned trial judge was correct in applying cases such as CalCorp rather than Zenith.
But I think the reference made by the appellant was to illustrate that the issue of acknowledgement is critical, and in Zenith, as you just confirmed, there was no acknowledgement. So in a sense, it's really just another instance confirming that depending on whether you think there's an acknowledgement or not, will be very significant to the conclusion about whether it's a penalty.
and we fully embrace that statement of law, Your Honour. What we take issue with is the appellant's sought analogy to the facts of Zenith, as was noted by Justice Nettle in Calcorp, that concerned a debt which made no reference at all to a prior debt. A deed which made no reference to a prior debt, and there were no references either in the prior proceedings in the defence, and that is not the case in the present situation. Your Honours, I now turn to a construction of the deed in question. Our submission is that even if Your Honours are not minded to consider prior pleadings and other evidence, the terms of the deed itself are sufficient to establish an acknowledgement of indebtedness. This much is evident on an analysis of three features of the deed. Firstly, the express acknowledgements of debt. Secondly, the inclusion of an interest rate in clause 2. And thirdly, the fact that the deed refers to this payment as the whole $650,000. Firstly, Your Honour, and most conclusively, the agreement expressly acknowledges the debt at 3 points in the deed. Now, if Your Honours will turn to pages 6 and 7 of the appeal book,
Yes, we have that.
you will see that at the first recital, the deed states that makes reference to an indebtedness to the said John Money in the sum of $650,000. This is subsequently referred to as the said acknowledged indebtedness in clause 1, and also on the recitals, the deed states that the appellant hereby expressly acknowledges the said indebtedness.
Yes.
Now, on this point, my learned friends have placed great emphasis on the presence of the phrase without admission of liability in clause 1. This is a supposed inconsistency that we submit is critical to the case in issue. My learned friends have further relied on the authority on Franklin's and Metcash, pardon Your Honours, for the proposition that where there is such an inconsistency, a clause will override words in a recital to a deed.
And you'd accept the latter as a general proposition, wouldn't you?
We do accept the latter as a general proposition. However, we first note, Your Honours, that if you turn to page 7, you will note that one of the 3 mentions of acknowledging indebtedness also occurs in the operative first clause. So this question is not merely as simple as one of clauses overriding recitals. Rather, our primary submission is that there is in fact a distinction between the meanings of the words liability and indebtedness, such that the appellant can deny liability and nonetheless acknowledge indebtedness, and these phrases are not inconsistent.
Just develop that for us.
Your Honours, we submit that it is instructive here to consider an example of a mortgage. If I take out a mortgage on a house, as soon as I take out that mortgage, I am indebted to the full amount of the mortgage that I take out. However, I am not immediately liable to that full amount unless I, for example, breach terms of my repayment plan, breach certain instalments or multiple times, as the contract may be. We therefore submit that, given that there is such an apparent inconsistency, this in fact indicates that the parties did mean different things by these apparently inconsistent words, and that the appellant's denial of liability does not indicate a denial of indebtedness, but rather, as is the purpose of a deed of settlement, it simply intends to settle the proceedings without admitting that an immediate liability is owed. And on this point, Your Honours, we note that what is required by the Calcorp test is not a liability that is actionable at the time of the deed, but rather an acknowledged indebtedness, and that this is satisfied by the present deed. Your Honours, if you are not minded to accept this submission, and if you accept my learned friend's submissions that there is some intractable inconsistency between these two phrases, we submit that this, in fact, gives rise to an ambiguity, and in that case, the court should have regard to the pleadings which merely confirm that there was an indebtedness, as I will establish later. Your Honours, we submit that this interpretation of the deed is confirmed by 2 other elements of the deed itself. Secondly, the deed makes reference to interest rates in clause 2. We submit that this is a clear indicator that the $650,000 sum had been owing for some period of time, as if it had not already been owing prior to the formation of the deed, there would be no reason why the parties should include an interest rate. We submit that this is a clear implication that it was already owing. And thirdly, the deed refers to the stipulated payment in clause 2 as the whole $650,000, indicating that this sum is intended to reflect a larger pre-existing debt rather than the smaller indulged amount, similar to the effect of words considered in the deed in Howell.
Isn't it possible that the provision for interest simply apply to the period between the date of the deed and the date on which the default amount is eventually paid?
Your Honours, if that were the case, we would expect that a provision for interest would also be included in the first clause, which it is not. We therefore submit that this merely indicates the interpretation that the first clause refers to a payment that does spring from the deed itself, to use the language of the court in Cameron and UBS, whereas the second clause does not. Your Honours, this conclusion is only affirmed by reference to evidence extrinsic to the deed, and our submission is that the trial judge was correct in having regard to this evidence. I will first consider the admissibility of the prior pleadings. We submit that it has been clearly accepted by this court in both Cameron and UBS and Calcorp and Collins that in constructing a deed of settlement, it is not only permissible but the correct approach to refer to prior pleadings. As stated by His Honour Justice Nettle in Calcorp, the terms of settlement are to be viewed in the context against the historical background of the lease and proceedings. And His Honour also made express reference to the appellant's defence in that case and the admissions that it made in relation to the debt. This is analogous, Your Honours, to the present case in which the defence to the prior proceedings clearly admits the existence of a debt. The appellant admitted in paragraph 1 of her defence that the respondent provided her with $650,000. And further, she states that it was a term of the contract that after 1 year the respondent could request repayment in monetary form. She then admits to receiving a letter from the defendant's solicitors a year later, which would, by her own admission, constitute a request for repayment, and by her own admission would then give rise to an obligation to pay the $650,000.
But the defence is pretty clear, isn't it, that it denies the existence of any debt, and it pleads in 1A little b that it was a term of the contract that the repayability or not was a matter to be decided in the future.
Your Honours, and we submit that over the page, at page 5 of the appeal book, the appellant then concedes in stating that she received the solicitor's letter alleged at the particulars of paragraph 2 that she did receive such a request for repayment.
But she says, she pleads quite the contrary, that your client failed or refused to tell her whether he wanted to be repaid.
Your Honours, we submit that this argument that she makes is in fact inconsistent with the fact that she sets out in her defence, that in admitting that she received that letter, she in fact contradicts her argument that she received no request for repayment.
Yes, thank you.
Your Honours, I note that I'm short on time. May I request an extension of 2 minutes?
Yes.
Thank you, Your Honours. So, Your Honours, I've just briefly outlined why reference to the prior pleadings is admissible. I further seek to submit that the Honour did not err in considering the oral statements of the defence. However, given that I am short on time, I will merely note that this evidence was not central to the learned trial judge's decision at first instance. He goes on to say, after considering it, I do not have to make any decision about the terms of the loan or whether there was to be an investment, and we therefore submit that whether or not this evidence is considered is in fact immaterial to the outcome reached by the trial judge and that should be reached on appeal. Your Honours, I now wish to move to the argument in the alternative that if Your Honours find there was no acknowledgement of debt, we submit that clause 2 is nonetheless a penalty as it falls within the second exception to the doctrine, that is, it is an alternative stipulation. The archetypal example of an alternative stipulation, Your Honours, is set out in Metro, Goldman, Mayer and Green, heard by the New South Wales Supreme Court and approved by the High Court in Andrews. In that case, a contract between a cinema and a film company conferred the right to one screening only. And if the cinema showed the film more than once, it was obliged to pay a fee of 4 times the original screening fee. His Honour Justice Jacobs in that case found that the larger sum was not penal in nature as the cinema had simply exercised an option under the agreement to pay a higher fee in return for being able to show it more than once. Similarly, in the present case, we submit that the appellant simply exercised an option to make her repayment after the 30th of March and hence to repay a greater sum.
The agreement doesn't give her any right to pay it after the 30th of March, does it?
Your Honour, our submission is that the existence of Clause 2, in fact, grants her a right to make that repayment on or after the 30th of March and thereby to pay a greater sum.
So your argument is that she can pay $100,000 by the 30th of March, and on the 31st of March she'll pay $650,000. Immediate liability the next day, and that's the alternative stipulation.
Your Honour, we note that in the absence of any term stating that the liability is immediate, it is likely that the appellant would in fact have a reasonable time to make that payment. However, regardless, in considering whether a clause was penal in Metro, Goldman Mayer and Greenham, the court did not consider whether or not it was a reasonable term or a reasonable business choice by the contracting party to exercise that option under the agreement. In fact, in that case, a 4 times greater fee to simply show a film would be considered not to be a commercially prudent decision. However, nonetheless found that it was an alternative decision as an alternative stipulation as the party had the option.
So the question of construction there is, should clause 2 be seen to be an agreement by the appellant if she chose to pay the higher amount subsequently, but her first option on this construction was to pay the smaller amount earlier.
Precisely.
They were alternatives to each other.
Precisely right. And we note again that if Your Honours are not minded to accept this submission, it is in the alternative to our earlier submission that there was an acknowledgement of debt.
Thank you, we understand that.
Your Honours, I know that I'm out of time and that concludes my submission.
Thank you for your assistance. Appellant in reply?
Yes, sir.
I'm sorry, I've jumped the gun. We just need to do our marking. During the counsel for the respondent, and then we'll call you in reply. That's it.
May I please the court? Your Honours, 4 quick points. The first concerns the intention to be bound, and in particular the difficulty that my learned friends have faced regarding clause 3. They've suggested that clause 3 prevented any further substantive changes to the agreement. But Your Honour, there are 2 difficulties that flow from that position. The first would be that if any changes can't be made, presumably, then the solicitors would be unable to fix the problems like that there was no agreed interest rate, although it had to be agreed according to clause 2, that there was no deadline for clause 2, and so in that sense...
It meant to be a reasonable rate, wasn't it? Could we not imply that it would be agreed or otherwise fixed at a reasonable rate? Is that not a reasonable implication?
There would be the potential for an implication, Your Honour, but then the question would be, what would the rate become? My learned friends contended the Supreme Court Act provides some options, but of course the recitals in this deed refer to $130,000, and then if we were to compound the $650,000 alleged principal by 12% over 2 years, I'm taking those words from the statement of claim, then the amount would be $165,000. So we have 3 options and no way for the court to determine which, if any, ought to be implied.
But I take it you accept the force of the phrase at the end of clause 3 on the above terms and conditions.
Well, Your Honour, it's certainly a relevant part of the language, but
It suggests, doesn't it, that the intention is that what the lawyers will do will be to embody what has already been agreed. Would you accept that characterisation?
Your Honour, with respect, we note the same language in Masters and Cameron did not lead to that conclusion, and on our submission it would still be possible for further substantive terms to be added by the lawyers.
Yeah. Thank you.
Thank you,
It
Your Honour.
doesn't foreclose that, you say. It's an indication to the lawyers that it's at least what we've agreed, but we leave it to you as to whether there's anything else.
We would humbly adopt that.
Yes, I see. Thank you.
Secondly, Your Honours, turning to this question of is liability the same as indebtedness?
Perhaps just before you do, I can go back to clause 3. Whilst there are certain conditions or terms that are not part of the above terms and conditions, for instance interest, insofar as the above terms and conditions are expressly set out, is there scope for the solicitors to vary those expressly set out terms and conditions?
If the agreement was binding, Your Honours, then no, there wouldn't be scope to change. But if the agreement wasn't binding, then the parties would be at liberty to draft the second agreement on our submission.
It's a bit circular, isn't it? You're relying on the agreement not being binding to prove it not being binding.
Yes, Your Honour, I acknowledge that there is a level of circularity there. Your Honours, the final point I'll just make in light of the time was regarding this liability versus indebtedness point.
Yes.
And I would simply suggest that it's unclear that the parties would have appreciated the very fine aspects of that language. Perhaps the analogy to mortgages didn't clarify so much as muddy the waters. May it please the Court, those are our submissions.
Thank you for your assistance. Now the respondent.
Your Honours, two brief notes in Sarah rebuttal. Firstly, our learned friends have pointed both in their written submissions and in their rebuttal to the requirement that the agreement must be acceptable to the parties' solicitors, and they've relied on that to infer that there must be the possibility for substantive changes to occur. However, we note that it was the solicitors themselves that had these proceedings dismissed, and once again, on the construction of this evidence, we've submitted it's therefore likely that the solicitors did indeed find this deed acceptable and saw no need to alter or update the terms of it. And once again, we point to indeed the lack of subsequent conduct. If the solicitors had read this and found that then it required substantive changes, one would have expected that in the 8 months that lapsed, there would have been substantive changes made.
Yes, we understand that.
And we submit this furthers our point on intention. Secondly,
one thing is, Skinner, that is, if this agreement's enforceable, and let's say your client is entitled to the amounts that it provides for, would your client have to waive its right to interest, or if not, how would it seek to establish the amount?
sorry, Your Honour, could you please clarify
Certainly.
the question?
If the contract's enforceable,
Yes.
does your client, could your client have a right to enforce the claim for interest? And if so, how would it do so?
Your Honour, we would be seeking that the right to interest would also be enforced as per the terms of the agreement, leaving term 2.
And reasonable would be assessed by whom?
We would be willing to either accept a rate set out by the court or would have it to be agreed upon by the parties' solicitors. Your Honour, noting the time, one final point on the distinction between liability and indebtedness. We note that these are not entirely unsophisticated parties, and we simply submit that our learned friends have placed too much weight on the fact that these parties were not lawyers, and that weight should be indeed placed on the fact they are business people with an understanding of commercial terms.
Thank you very much. We're going to retire now and finalise our evaluation. As I think everyone's aware, we're not announcing a decision in the moot. Now that will be announced tonight at the gala event. But we will come back in a few minutes and make some general remarks about the advocacy, and we're happy to take questions either from those who've done the arguing or from anyone else in the audience about either the advocacy or the issues. Yes, we'll be back in about 5 minutes. Summing up of the performance can be put quite briefly. It was simply outstanding across the bar table. We see a lot of counsel, both in the Court of Appeal, Justice Forrest and myself, Justice Reardon, head of the Commercial Court, Justice Forrest having been a criminal trial judge before he came to the Court of Appeal. Each of you would hold your own in the Supreme Court on the strength of your performances today. It's a great credit to you and, of course, the others in your teams, but also to the quality of the competition. I imagine there are others in the audience who've been in earlier rounds. We have reflected on the level of sophistication, poise, confidence in all of your submissions. And we would be pleased to have performances like yours every day in our courts, I can assure you. I suppose when you become old and disillusioned, you, as counsel, I mean, not as judges, we're neither of those things. You might not take quite the same trouble that you take when you're young and keen as you are, but don't ever lose sight of that, the standard you've set yourselves, because it's one thing to appear in a grand final moot, but when you're before a magistrate at Frankston, it's got to be as good as what you did today. Or a judge in a difficult trial in the county court, it's got to be as good as you did today. And as you know, doing the preparation in the way you've so obviously done it makes the appearance very satisfying. As I often say to young lawyers, you know more about this than the judge or magistrate does. And that should give you a confidence. It doesn't mean that every argument will be accepted, but you should stand up knowing that there's virtually nothing that you can be asked you won't be able to answer. And that's another aspect of your performances. You, without exception, were able to respond to our questions. None of you were put off your argument, but you paused, accommodated the question, responded cogently, helpfully, respectfully. Again, just really model performances. And as I say, you will find in your careers that that kind of preparation will stand you in good stead, whatever you're doing, whether it's giving advice or appearing in court. It is, of course, possible, as I eventually learned as a barrister, to say to a judge, "Oh, I don't know the answer to that question," and a couple of you did that. That's perfectly acceptable. It's not a sign of failure or a sign that you're going to lose the case. You're much better to say, "No, I don't know the answer to that." And you'll find some judges who know all the cases in the Commonwealth Law Reports and will ask you about one you've never heard of, and you just have to say, "No, Your Honour, I haven't read that." and you say to yourself, now can we get back to the real issues? So, really outstanding. A credit to yourselves and to your community of law students. A couple of specific things. Always good to have a measured pace in your submissions. Don't go too fast. Important, so far as possible, not to read, not to prepare a script in advance. I guess the way we would formulate it, and this is Justice Forrest's wisdom, you should be confident when you stand up that you've got in your mind what's in your notes. And given the way you've performed today, you should next time feel completely confident. Once I've thought about it, prepared my written submissions, I can stand up and do this from memory. And the advantage of not reading is that you're looking the court in the eye, but you're also subconsciously reformulating the way you express it, which will be slightly different this morning from what it was last night when you did your notes, because you've heard arguments you hadn't quite understood or expected. It just gives you that flexibility. A concession of the kind made by one of the Appellants' counsel, if wisely made, is a great enhancement of advocacy. This is often not understood. Counsel, we've all had this experience too often, of counsel who doggedly stick to a point when it should be apparent to them that it's not succeeding, or that the judge thinks it's not succeeding, and that's usually all that matters. And it's, again, not a failure to say, no, Your Honour, I would have to concede that that was so. It tells the judge that you really know what you're doing. Sometimes you have to explain to the solicitor why you did it, but it's worth highlighting because it's still rather too rare in our experience. A couple of particular things. Although the task is, with the contract, is the task of construction, you talk about construing an agreement, not constructing it. This is quite an important linguistic distinction, and I'm only drawing attention to it because that was a phrase used a couple of times. So, legislative construction or interpretation, but what we're doing is construing the statute or construing the agreement. Again, don't need to use the word humbly. Respectful's enough. And I think we'd all agree that one or two in my respectful submissions is enough for one argument. I'm not suggesting any of you overdid it. We had counsel in the Court of Appeal a year ago who began every submission with, and in my respectful submission, so and so and so, and you then feel, well, the appropriate courtesy is just getting in the way of getting your message across. The way you engaged with us was the clearest expression of your respectful attitude to the court. So you don't, as it were, need to keep saying it. Lastly, just make sure your hand movements don't distract from your oral presentation. It's tempting, but, and Justice Forrest may want to say that in some settings, especially before a jury, you can do a lot of work with your hands. But where it's essentially legal argument, let your facial expressions and your voice do the work.
Well, some people need to move their hands. I never noticed that I moved my hands when I addressed the jury until it was pointed out to me by my learned president. It's very much part of who you are, and I think the most important thing when you are commencing as an advocate is to be yourself. And if you do the reader's course, you'll be shown videos of your appearance in moot courts and how you've addressed the bench and how you've made your points, and all of that's good advice, but the best advice is, in my view, be yourself. As to the in my respectful submission, I usually, when I hear that, think that counsel is filling in time while he or she gather their thoughts. The other thing that you should avoid is saying, with the greatest of respect, Your Honour, because those of us who've been on the bench a little while know that that is the prelude to some insulting remark. And so we take a special interest in the next sentence. I agree with the President about not being too humble. Humility is wonderful, but respect will do. We don't need too much in the way of humility. On the question of believing in yourself, if you've done the preparation, which obviously all of you had today and all of you when you appear as advocates will do, be confident that you will remember what you have written out. What I used to do, and more so in final addresses than in the Court of Appeal, but I would write out pretty much every word of what I was going to say. I would summarise it back. It would end up as bullet points. And times have changed. People don't use pens as much these days as they did. But by doing that, it was in my mind. I knew exactly what I wanted to say and how I wanted to say it. And I would then put my, hopefully, one page of bullet points to one side on the bar table. I would look at the jury and I would tell them about our case. If I thought I was wandering off structure, I might glance down at the notes, but only for a short time, and then I'd be back looking at the jury. A very great barrister who's now departed, Graham Morris, once told me, when I was instructing him, when I was a solicitor, that if he said more than 70% of what he intended to say, and he looked at the jury while he was doing it, throughout his final address, that was better than saying 100% and reading it, because the jury would take in a great deal more with the former rather than the latter. The only other thing I wanted to say is that the last grand final that I appeared in with the President was in 1971, the Melbourne University Football Club. Peter.
I don't want to do anything more than just endorse what's been said by the President and Justice Forrest and say what an outstanding job I thought everybody did who appeared today. It would be a pleasure for you to appear in my court. I look forward to seeing you one day. Thank you very much.
Thank you, Your Honours. We have Justice Forrest on our far right, President Maxwell and Justice Riordan. I'd just like to request if we could take a picture with the competitors down here, if that's okay.
Good, certainly.
Yeah. Just a little. And then we can take it
Thank you so much.
Yeah. Good.
Thank you.
See you at the dinner tonight. Quick show, mate. Good. Thanks.